Called to order as soon as, here we go. The lights are on. Meeting's called to order. Bienvenue, collègues.
Welcome, colleagues.
Meeting number 86 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference adopted by the House on June 21, 2023, the committee's continuing its study of Bill C-321, an act to amend the criminal code, assaults against healthcare professionals and first responders. Today's meeting is taking place in a hybrid format pursuant to the House of Order of June 23rd. Members are attending in person and remotely using Zoom. Those that are on Zoom have already been tested and everything seems to be okay. And since it's only colleagues that are on Zoom, I don't need to, I assume by now you all know the procedure for raising your hand and speaking, and so I won't go through all of those formally. Alors, je tiens à vous souligner.
So I want to assure you that the sound tests have been carried out successfully.
Our study with the clause by clause. We have from the Department of Justice, Mr. Matthias Villetort, Senior Counsel and Team Leader, Criminal Law Policy Section, and Madame Leah Burt, Counsel, Criminal Law Policy Section. Bienvenue. Welcome. So just a few remarks, and I will be very brief. As the name indicates, this is an examination of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it, who may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in the bill or in the package each member received from the clerk. Members should note that amendments must be submitted in writing to the clerk of the committee. And I'll go slowly. There's not a lot this afternoon, so during debate on an amendment, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing. They do not require the approval of the mover of the amendment. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. And then, of course, at the end, once it's all done, committee will vote on the title, order to reprint the bill if amendments are adopted. Finally, committee will have to order the chair to report the bill to the House. So we'll begin. Pursuant to Standing Order 75, Sub 1, in consideration of the preamble is postponed. I will call Clause 1, G-1, and I will ask if the member wishes to move it. Mr. Maloney wishes to move it. Thank you. Any discussions on it? Oui.
J'aurais un sous-amendement.
I will have a sub-amendment to move, Madam Chair. It was circulated. The interpreters were not given a copy of the sub-amendment. It is intended to change the words from saying they must to they may. When we had the hearings, Mr. Justin May, who is an ambulance driver and who's a clinical researcher and a professor at the University of Toronto, he's working on his doctorate currently. So he appears to me to be a person who's qualified to answer the question They're the issue that we have with Bill C-321. So he said during his testimony in answer to a question that would you think it would be better to say that the court must and replace it with they may, and to leave the discretion to the judge that if he's going to consider that there are aggravating circumstances or not. And he answered, yes, absolutely. And so I'll spare you reading through all of his testimony, but he said, I think it's important to take the context into account when decisions serious decisions have to be made. So what we can see, Madam Chair, is that it's a good idea in perhaps 95% of the time to say that there are aggravating circumstances when someone has assaulted a healthcare worker, but there can be circumstances under which that's not the case. And he gave the example, Mr. Mass, of a person who was under the influence of adrenaline, I believe. I don't remember exactly, but caused by an accident. So everyone recognized that he was not a violent person. And so he said something like, I'm going to kill you. But it wasn't a sincere intent. It was just because the person was under the influence of adrenaline. And the ambulance people recognized that as well. So I think we have to leave judges a certain amount of discretion, that they're the ones who hear the testimony. And if they feel that there are indeed aggravating circumstances, they may find that to be the case, but they're not obliged to add to the sentence if that is the case. So I think that it respects all of the testimony that I heard, and in order to try and be fair, we should replace est tenu with peut in the French version.
Followed by Mr. Caputo. Okay. You decide.
Well, look, with all due respect to Mr. Fortin, I think to say a judge may consider as an aggravating circumstance would really take away a lot of the impact of what we're trying to achieve here. We want judges to consider that an individual that's been assaulted is a healthcare provider or a first responder. A judge may consider those things now. So to say may is basically to suggest, in my view, status quo, because a judge could certainly consider that when considering sentencing. So I would respectfully disagree with this amendment, or this sub-amendment.
Okay. Can I, as the chair, ask clarification from the officials in the room, please? Monsieur, wait.
Yes. Sorry, clarification with respect to?
With respect to the sub-amendment and what Monsieur Fortin and Mr. Moore.
So the impact of the object of the proposed amendment would be that, as Mr. Moore pointed out, a court at sentencing, and Mr. Fortin pointed out as well, at sentencing, a court would not be under an obligation to consider that situation as an aggravating factor. Now, the aggravating factor is part of the sentencing process, and it doesn't take away the fact that a court will still have to impose a sentence that is proportionate to the seriousness of the offense and the moral worthiness of the offender as well. So shall consider to have an aggravating factor, as we have in 718.2 and other places in the criminal code, where it's deemed aggravating factor, meaning in all circumstances they shall be treated as aggravating, doesn't foreclose a judge from imposing a sentence that is proportionate to the circumstances.
So, just to clarify, I said clarify, I meant advice. Thank you. No, just my English sometimes, I have to think in 3 languages sometimes, and so I just wanted to clarify that. I've got a number of people that have their hands up. I've got Mr. Caputo, Monsieur Fortin, and Monsieur Davies.
Thank you, Madam Chair. Just to build on what Mr. Moore said, the reason why we're here and the reason why this private member's bill was moved was precisely what is required. That a sentencing judge shall consider this. In other words, it's compulsory as opposed to it may consider it. Essentially, we're gutting the whole purpose of the bill if we were to change it from may to shall. Shall is compulsory, may is permissive. If it's going to be permissive, we might as well not even be here. So I would be against this amendment. Thank you.
Okay, Monsieur Fortin, Monsieur Davies, and then Mr. Housefather, I do see your hand as well. So,
Merci, Madame.
Thank you, Madam Chair. I simply wanted to remind you of the part where Justin Mouse said to us, as a witness, that one of my colleagues, the president of our union, as it happens, was assaulted by a patient who was under the influence of mushrooms, I believe. And it was just a young man who'd made a bad choice. And he knocked over my colleague. He suffered a concussion and he couldn't work for a certain length of time. So that young person took a bad decision, and he should be made responsible for the decision, but not necessarily to spend his life in prison for it or see his life ruined. And that's what I'm thinking about as I table this amendment. And I quite agree with my colleague, Mr. Caputo, and Mr. Moore as well, to the effect that the court must consider all of the facts before them, and this is a major factor. The fact that the person assaulted was a healthcare worker, but I'd still maintain that the judge must have the latitude to be able to say, I'm not going to increase that person's sentence. And there's another article in the criminal code that says that things can be considered as an aggravating circumstance, and I forget the word that's used, but that the sentence can be made more severe or less severe. So here, we're not giving that latitude. We're saying that the judge must. The judge would have no choice but to impose a stiffer sentence. And if 90% of the time it may be a good thing, but in some cases it's not. And I think that we have to trust our courts and let the judge, who's hearing the bulk of the facts, take the right decision. Thank you, Madam Chair. Thank you, Mr. Fortin.
Thank you, Madam Chair. Well, it's a pleasure to be at this committee. I'm a visitor, but I have a question and a comment to add on this. I have some background on this. I've introduced legislation as private members' business on this very point in the past in previous parliaments to make an assault against a healthcare professional. It didn't have the first responders aspect, an aggravating factor, so I have some background in this, and we also heard evidence of this at Health Committee in the past. I find myself in very much in agreement with Mr. Moore on this, that the state of the law, I would think now would be a court may consider any factor that it would consider germane or salient at this point. So if we put the words it may consider as an aggravating circumstance, I think it would be no more than restating the status quo. I think what we want to do is we want to change the status quo to send a clear message to society that assaults on healthcare workers are always wrong, are never okay, and it's always an aggravating factor. I'm fortified by the advice, if I'm understanding it correctly, that does not change the fact that the judge would still fashion an appropriate sentence, taking into account the very appropriate considerations that Monsieur Fortin identified that may work to ameliorate the sentence. But the fact that if we want to send a clear message that that assaults on healthcare workers are simply not tolerated in society, and I remember the testimony vividly at Health Committee to the effect that it's almost epidemic, that it's happening all the time, not just in hospital, but ambulance drivers, paramedics are facing this all the time. We must send a clear message. So those are my comments. My question is, and I think, if I'm not pronouncing this correctly, Mr. Villetort touched on this. In the other sections of the criminal code where there are similar situations, I think it's an assault on a peace officer and maybe on transit drivers, if I'm not mistaken. Does it say shall or does it say may? Or is it expressed as the court must consider that as an aggravating circumstance, or does it give the kind of discretion that Monsieur Fortin's sub-amendment is suggesting?
So thank you for the question. The aggravating factors in the criminal code are deemed to be, so it's shall consider. If we look at 718.2, as Mr. Fortin was pointing out, it.
others on there?
There's others on the line that they do have sound, so I'm gonna. Okay, Monsieur, I think you were done, Monsieur. Monsieur Fortin, I know. C'est à vous.
Monsieur Fortin, you have the floor. Thank you, Madam Chair. I'll do this quickly. My point, really, I wanted to read, at least in the French version, I don't have the English version, but 718.2, Mr. Viltorte, what I read in 718.2a, that the sentence has to be adapted to attenuating circumstances. And the interpreter doesn't have the criminal code in front of her to quote this, but at 3 small eyes point 2, we talk about offenses against a person who was providing healthcare services. So we're saying that 718.2a, that the sentence should be adapted. So am I not correct, Mr. Viltort, to assume, I am in the French version, I don't have the English one, that the sentence should be adapted and doesn't create an obligation, but rather it is a suggestion? So I just would like to hear you on that. I think that you speak French, unless I'm mistaken, so perhaps you could enlighten me on that. And I'd just like to add, too, that I have that concern of the consistency. I'm concerned that they would be, the court would be obliged to do this under 269-2. So I'd like to hear you. Well, if we take a step back, 718.2a explains that it's not an issue of aggravating circumstances. This is about the sentencing principles, and so aggravating circumstances are part of the principles of sentencing. So the judge is the one who always has to take into account the proportionality and the degree of guilt. So they have to take into account attenuating or aggravating circumstances. But if we read the rest of it, before we set out the list of situations, it says, amongst other things, that the following situations are aggravating circumstances. So I think that it's a drafting issue, the way that it was written in that way. So they decided to set them out like that to ensure that those particular circumstances are always aggravating. Ms. Brière, thank you, Madam Chair. I would just like to say, if we're talking about consistency, that the wording of 321 picks up the wording in 269.01, where they say that they shall consider as an aggravating circumstance, and so forth. So we're keeping the same wording there. Okay, are we ready?
No. Okay, on va voter pour le
Okay, we are going to be voting on the sub-amendment.
amendment, please. Would those in favor please signify by saying aye, raising your hand? Okay. And those that are against? Okay, merci beaucoup.
Thank you very much.
What do I do?
And then we're going back to the amendment, G1.
Okay, we're now going back to the amendment for G1, and having no one raising their hand to speak on it, shall G1 carry? Yes. Thank you very much. G1 is carried. We will now go to CPC-2. Moved by Mr. Moore. And any debate? Anybody wishes to speak on it? Okay, fabulous. We will now move to the vote on CPC-2. Shall CPC-2 carry?
Sorry, can I don't-
Yes, of course.
I'm sorry, I don't have it in front of me.
Okay, let's wait a minute.
This amendment does is provide a definition of first responder, similar to how there was a definition of healthcare providers. So persons employed or engaged on a volunteer basis, employed or formally engaged on a volunteer basis to be among the first on the scene of an accident, fire, or other emergency to provide medical assistance or firefighting services, and includes an emergency medical technician, a paramedic, and a firefighter.
Apologies, I did have it, thanks.
Any further debate or questions to our officials? Oh, okay, Mr. Housefather.
Thank you, Madam Chair. I just did have a question for the officials with respect to the new proposed definition. In my view, including that definition sometimes is good. I mean, sometimes it's good, sometimes it provides clarity, sometimes it may unduly restrict what the intention of the bill was. Could I ask the officials if they believe that the proposed definition restricts who may be considered as a first responder or actually brings context that's important to the bill?
Thank you for the question. So I think when we're looking at defining terms in the criminal code, it can be useful, but it's important to consider which persons and activities are going to be captured and to ensure that it's not inadvertently excluding certain groups that were intended to be captured by the bill. And it's also important to ensure that terms are internally consistent within the code. So first responders isn't defined elsewhere in the code, so that's not an issue. But I guess I'd just say that the wording, we don't have, I should say we don't actually have the CPC-2. All we have is the CPC-1. But I think my understanding is the definition of first responders is the same. I have that wording in front of me. I don't have the new.
It's the same.
Okay.
I think it's the same. That's the source of my confusion.
Okay. Oh, perfect. Thank you. So I guess the question is what is intended to be captured by the bill. So if the intention is to capture first responders, medical personnel such as firefighters and paramedics, then it seems like this definition would capture that. There are, of course, other categories of personnel who are in some circumstances considered first responders, such as correctional officers, probation officers, military personnel, who may not be captured by this definition. And this definition also, I think, is specific to the provision of medical assistance or firefighting services. So, for example, would a correctional officer who's responding to an emergency in a correctional facility that's not a medical emergency, would they be captured by this definition? Possibly not. So I guess it's really a question of what's intended to be captured by the bill.
Thank you. I think that is very helpful. All right. Seeing no other hands raised, I'm going to ask, shall CPC-2 carry? I hear yes, I hear no. Okay, so recorded vote. Do I start with the yes? With those or I guess we do it differently here than what I used to do. Okay, so go ahead, Mr. Clerk.
Thank you, Madam Chair. On CPC2, Mr. Maloney.
No.
Madame Brière.
Nope.
Monsieur Mendicino. No. Monsieur Housefather.
No.
Madame Dillon.
No.
Thank you. Mr. Moore.
Oui.
Mr. Waugh.
Yes.
Mr. Caputo.
Yes.
Mr. Van Potta.
Yes.
Mr. Fortin.
Oui.
Mr. Davies.
No.
Nay 6, ye 5 defeated.
Okay, it's defeated. Now we will move to carrying of Clause 1. So shall Clause 1 as amended carry? Yes. Those in favor, yes. Any nays? Thank you, carried. Preamble. G2. Can I ask for the member to, if they wish to move it? Mr. Maloney moves it. Thank you. Is this the one? Shall G2 carry?
Yes.
Thank you. G2 is carried. Shall the preamble carry? As amended. Merci beaucoup. It's amended, carried as amended. Title. G3. Shall G3 carry? Mr. Maloney moves G3. Thank you. Shall G3 carry as amended? Yes. Thank you very much.
Sorry, so G3 just carries.
Is carried as amended. Shall the title carry as amended? Yes, I hereby carried. Shall the bill as amended carry? Which of the two options they wish? Mr. Moore.
Thank you, Madam Chair. Yes, we're fine with proceeding as planned to have C40 on Tuesday and then the minister appear on Thursday next.
Fabulous team. Thank you very much. So I need a motion before you leave. I need a motion that in relation to the clause-by-clause study of Bill C-40 on Thursday, December 5th, the deadline to submit amendments is tomorrow, Friday, December 1 at noon. Can I please have a mover of that motion? Mr. Van Popta. Merci beaucoup. All.
Thank you very much.
Yes, thank you so much. Everybody have a lovely evening and a lovely weekend. Merci beaucoup.
Thank you very much.